Hey, Brian Parker here. I got a fun series. I've got 5-part series here on examining the collection lawsuit. I'm going to take you places you didn't think of. I may be repeating myself. That's a good thing because we all need stuff repeated to us. But I'm going to look at something that I don't think you've ever seen before, but there's gold in them hills. So what I want you to think about when you get that collection lawsuit is, how do I beat it? You know, that's my number one thing, and really my number one thing is build the counter-affidavit. A lot of these videos are going to be all about number 5, video 5. So check out video 5, which is how you build the counter-affidavit. You do it by beginning at the summons and before the complaint. I always advocate tear apart that complaint, and that's good, but we want to take a look at some gold that I've been neglecting you. I haven't been fully telling you some good stuff here. So we're going to talk about the summons. That's, again, on top of the complaint, and you get that. You're being summoned to court, and I'll show you how and why that can benefit you. So let's take a look at a typical summons. Shazam, that's a general summons. And I say general meaning that's a Michigan summons, but there are different variations on the same theme. Everybody has a summons asking you to come to court, and they are asking you to come to court in a certain amount of days or face a default. So let's look at our first fun fact, a tip. You'll see at the top there is a place for the defendant's name, address, etc. You'll be, at this point, you won't be surprised that a lot of times the name is wrong, the address is wrong. Those are all things that you can put in your counter-affidavit, and having your name wrong usually belies the fact that this is long gone. You've been married, it's a divorce name, it's this, or they're even just wrong, or the address is wrong. In this case, my client did not initiate. It was a ID theft case, so he knew that they had the wrong address and they had the wrong guy. But take a look at what they did. If you look at the section, let's emphasize the civil case, Shazam. And what a summons is, it is an explanation of your rights, the times, who is being sued and by whom. It's notice, it's part of our due process. And that part that shows you there are no other pending or resolved civil actions here under the same facts and transactions is checked off. Well, in this case, my client was sued on the same case and same facts in a different county. He had to travel an hour to get the whole thing sorted out when they defaulted him on something he'd never been served. So this company is misrepresenting the fact that there wasn't a previous case. There was, but they checked the box there wasn't. So you've got to look for that. You've got to check the name, make sure the name is correct, your address. All that goes into, as we're going to talk about part 5, the counter-affidavits. We build our counter-affidavit. Again, in this case, because they sued him in the wrong county and doubled down by suing him again, he has possibly a case under the FDCPA under 1692I, 15 USA 16. You can't sue someone in the wrong district that they don't live in. These are quite sad facts, actually. His ID is stolen, and I'll leave it at that. But I'm illustrating the point that the summons has gold, things that you can use against the person suing you. So we're looking at the summons, and I want to take you to the section where there's dates, and you see the blown up, you have 21 days. Shazam, that is your notice. As notice to defendant, you, me, and it's saying you got 21 days to serve an answer on the court and the other side. Don't forget that, and make sure you have a proof of service that says I served it on the court and I served it on plaintiff. If you have 28 days because you got a mail service, now again, these are general numbers. It may be 20 in Florida or 30 elsewhere, but whatever the summons shows you, that's the rules you follow in your state. Here, it's telling you, if you're served by personal service, then you have 21 days. On your calendar, on the 17th day, put it so that you have an answer go out and do your proof of service that it happened, because things happen. The post office may be bad. You send it on a Friday, the weekend, yada, yada, and the minute you're late, the debt collector will default you. So if it's 28 days because you got it by mail or an alternate service, on the 24th day, make that answer go out with your proof of service. Look at the issue date and expiration date. Here it's 8/14/24, 11/13/24. If, and this happens, you get served with a summons and complaint, let's say in this case 11/15/24, it's over. It's as good as bad milk. It is no good to anybody, but they will serve you anyway sometimes. I've had it happen to my clients, and then tell the court, yep, we served them, and nobody checks if the summons was expired. So you're gonna have to do a little bit of paperwork, but that'll get you out of a lot of headaches if you just look at the small stuff. The small details are big sometimes. So you look at the issue and expiration date and all the fun things I just told you about, and they all go into your answer and defense of the lawsuit after you've done and built the counter-affidavit. So that's looking at the summons. Hope this is the beginning of help to you. This is the first part of 5 in a series of what to do with or how to analyze a collection lawsuit. Thank you. Hey, this is part 2 in the series of examining the collection lawsuit. And this is part 2, as I said, the complaint. I want to give you a quick tip from my last one that it bugged me that I didn't tell you this. When you are served personally, a process server is thinking all the time, am I going to have to defend this service? And his client maybe too. So they will hand you the process server and ask you to sign it, because it makes their job easier defending themselves if there was something flunky about the process service. I don't know of a law that says you have to sign that. And funny enough, during COVID, I told my clients, do not sign anything. The guy's handing you a pen. So don't help anybody that's trying to sue you, so you don't have to sign anything. If they're suing you, make it as hard as heck for them. Don't avoid service if it's right there and you close the door. But you don't have to sign anything. And I wanted to tell you that for the last video. This video, part 2, let's put up the same case that we're examining, and let's put up the first page, Shazam. So as you recall from that last case, my client had been served twice, once in a county they didn't live in, and now this lawsuit. And as you can see, right in the middle of it, it says, pursuant to, let's say MCR 2.113C2, there is no other pending or resolved civil action arising out of this transaction or occurrence alleged in the complaint. Well, from my last video where they clearly had been sued previously, that's a false statement. So right off the bat, that's something you can use to build your counter-affidavit. It has a caption, and that's hopefully saying the district that you're actually in. Look for that. Paragraph 2, that's telling the court, hey, we're suing in the right place, unlike when they did it previously. And here's the address. So look at number 4. Let's blow that up. Number 4, Shazamski. Are there any mistakes here? Well, there's a lot. They're saying they are the original creditor, PayPal credit. That's not a creditor or name of any company. Go Google it. Partnered with Synchrony Bank. That may be the original creditor, but the way they've said it is false, so that's going in your counter-affidavit. And then they continue on and they say, defendant has never provided plaintiff with any written or verbal objection to any of the statements. As you recall, this is a case where they sued him previously in another county he didn't live in, and now this is the second lawsuit. So that's an out-and-out lie. They know because they were there when he was yelling at them and the judge about, why am I being sued in a county I never lived in? And he won that motion. Judge agreed with them. So they know that. There's actually a court document saying that's a false statement. So you've got to look at these things. They're important. They are claiming, let's put up paragraph 1, Shazam, I skipped over that. This may seem innocuous, and I think that means not important, but that may not be true. Google, do a Google search. A lot of times, like there's a particular company, and I'm not going to say it, but it actually moved its operations to a different state, yet it was still using the allegation that was in the state of New York. Well, that's a false statement. It's another brick as you build this beautiful wall. If they lied here, they lied there. It's all about credibility, my friends. It's all about credibility. So check that out. Use Google to see even the most silliest things. Where do you live? Where do they live? They've got to rightfully say why they're suing you, where they're suing you, and they can't lie doing it. In this case, as you see on the first page, there's your old friend, the mini Miranda rule. That's great. No, you can't do that. No debt collector does that and sues because it turns the collection complaint, which is never a collection attempt or communication, into, well, let's just see. It says it's a debt collection information. They're collecting a debt. So there you go. They just screwed themselves and they lose immunities that they normally would have. And we've talked about why they do that. See my video, How Creditors Become Debt Collectors. And we've got lots of debt buyer and creditor videos. Just take a couple. There you go. Boom. So my client has objected to this lawsuit when they had defaulted him. So he has a court record of this lawsuit being false and the fact that he never objected to it. You also see that he's being sued on an account. What's an account? An account is normally somebody owns something and there's an accounting. So it's not a debt because it would say right here they're collecting on a debt, which they do not say. And we've talked about securitization. So you need to look into words. I've actually put many of my MCM videos, if you look at Midland Credit videos, there's a couple of them, Shazam. They will talk about, here's a definition of an account, here's a definition of a debt. The FDCPA, which regulates collection activity of debt collectors, does not have a definition of account. So why is the word account there instead of debt? Because they're debt collectors, right? Or they're debt buyers. Because the debt is long gone in the securitization process and all that's left is an accounting or a servicing. So the person suing you, if it's a creditor, is really a servicer. They don't own the debt and have no standing to sue you. Here, it messes up the chain of title, which will be in our video 3 of this series. So words matter, my friends. So do lies, so does credibility. You can look at the last page. It really is a nothing burger, Shazam, and that is just doubling down on something that wasn't true in the first 12 allegations that they made. But examine every word. Here's a good examination. Number 14 says, by virtue of the circumstances surrounding the request for funds made, comma, defendant knowingly requested the funds at issue and or knowingly and voluntarily accepted and or received the benefits bestowed. That's utter nonsense, okay? Put that in your answer and put that in your counter-affidavit as you build your counter-affidavit. If it's utter nonsense, say that, because anybody reading that goes, I have no idea what's going on, and the purpose of a lawsuit and the summons is placing you on notice of what you're accused of. I don't know what anybody's accused of and by whom, but again, my point is look at the words. They matter. They say nothing. So just bear in on their defects. You'll have your next video, which will be examining the bill of sale and assignments, or in this case, the lack of. And this concludes complaint examination part 2. Thank you. All right, we got part 3, the bill of sale documents. So we're examining the collection lawsuit with part 3. Those are the documents that are attached to the lawsuit that tell you, hey, we own it because just look at our documents. So let's look at their documents. You remember the first page we put up of the lawsuit, Shazam? And that is the explanation of what you see in your lawsuit. And if you look at the second page, let's put up the second page, Shazam. And that is what I want you to focus on, and that's number 5 is the most important part. Remember in my previous videos, what is the linchpin of the litigation? Those are my favorite. I love those, and then we talk about taking what they say and we plunk it into the counter-affidavit and the answer. There's one of the plunking videos, so let's get rid of those. So let's look at the linchpin here and have some fun with this silly lawsuit that was dead on arrival the second time they filed it. As you recall, they sued my client twice on the same lawsuit, then forgot to tell the court that they had filed it already, which is against the law. So if you look at the paragraph 5, Shazam, you'll see the original creditor assigned all the rights in and to the account to UHG, and as evidenced by the bill of sale at Exhibit 1. You may recall that the original creditor, I just put it up for you on page 1. I won't put it up again, but it is, the original creditor, according to the lawsuit, is PayPal Credit. So let's have some fun with that. They're saying the original creditor assigned all the rights. So let's take a look at their bill of sale, Exhibit 2. Let's put up Exhibit 2 bill of sale, Shazam. And that's our old friend Lynn Fisher. She will sign your title for food. Joke. But I envision her with a sign, I will sign your bill of sale for food. And evidence of that is, just look at that. The bill of sale shows her signing for all these different entities at different jobs, but there is no original creditor, PayPal. It's got to be there to give to the company that's started this whole thing, at least the bill of sale says, Synchrony Bank, formerly known as G Capital Retail. So someone has to give it to them, to give to RS Funding, to give to Synchrony Card Funding LLC, to give to Retail Finance Credit Services, and finally to the debt collector in this case is claiming the right to sue my client twice. There's some interesting stuff. So with this Lynn Fisher signed document, we want to ask, where's the authority to sign for all those entities? It doesn't exist, but boy, she sure has a lot of hats she wears. Where are the assignments of the debt between the entities I just mentioned? There are 5 of them. 1 is missing. Where's the original creditor? This is the most important thing. It's all about the original creditor. PayPal Credit is told, you're told in the lawsuit, paragraph 4, that is PayPal Credit. Nothing is in that bill of sale, the most important document that they point to at Exhibit 2. So as debt collectors do with the insecurity of putting out stuff that they know clearly doesn't do or say what it says, what they claim it says, and it doesn't, if that makes sense. I'm sounding like one of their lawsuits now. They have an affidavit of the original creditor confirming the sale that I just told you about. So let's put that up, Shazam, and it is titled Affidavit of Sale of Account by Original Creditor. So let's look at that. There is no PayPal Credit who we are told in the lawsuit is the original creditor. It doesn't exist. It starts with Synchrony Bank. Well, who gave it to Synchrony Bank? It is signed by Julio Perez, and a notary has said everything she's saying and signed for is true, and that's Amara Hernandez from the state of Florida. So they then, with that same insecurity, they back it up with an attorney saying, yeah, what was just said behind all that stuff, that's all true. She did that. They signed that. And it's called a certificate of conformity, and it's signed by a Florida lawyer for a Michigan case. That can't be a problem, right? And so we'll take a look and see if what they're doing is going to wrap this whole thing to show that everything is cool. So here's the New York, wait a minute, New York. It says New York COC Certificate of Conformity, Shazam. And that, if you see that, let me highlight this one section. And it says, the undersigned does hereby certify that he, she is an attorney at law, duly admitted to the practice in Florida, and that he or she has seen Ms. Hernandez and Mr. Perez sign this, and you can guarantee I have the right to do this under real property law of the state of New York. What's that got to do with? So now you've got a New York law signed by or used by a Florida attorney saying, yep, all those Florida people signed it and they conform with New York law for a Michigan case. So what is that called in my office? That's called Tuesday. That's an average lawsuit, just mess, because 90% of all lawsuits get defaulted. So they don't take great care in the lawsuits that I see, that you will see. So use their own documents against them here. New York real property law confirms a debt collection lawsuit. Even that is a whole plate of wrong. So that average day in my office is how you tangle and examine the bill of sales that support the DREC that you're facing with the summons that we talked about. Remember, the defects you found in the summons from part 1 of this series drop into or plunk into the video number 2, and now they followed through into here, video number 3, which is examining the bill of sale. Hope it helps you. Thank you. Hey, Brian Parker, and we have the exciting part 4 of examining the collection lawsuit. This is about the answer and affirmative defenses. You did the work on the summons, you did the work on the actual collector lawsuit, and you looked at and analyzed the bill of sale proofs. That's all gonna jump up and plunk into 2 documents. One, your counter-affidavit, which is part 5. That's the most important video and document. Build your counter-affidavit. And this one is part 4, where we'll look at the answer to your basic collection lawsuit. So every lawsuit is made up of counts. Your basic your basic collection lawsuit has 3 counts. One is the breach of contract, one is a account stated, and the other is a throwaway called unjust enrichment. I have people ask me about that all the time. I figure I'll do a video including it. When you get that document, that summons, I told you in video part 1 how to examine the summons. You looked at the answer at the complaint in part 2. Now we're going to rip apart and put a T by what's true in every paragraph, an F by every paragraph that is false or is unproven. So let's put up a basic breach of contract count, Shazam, and that's your basic breach of contract collection lawsuit. The key with a breach of contract claim is it relies upon usually the terms and conditions of a contract or that isn't attached, or just terms and conditions without any backup, or a contract normally that is not the one that you signed. It's going to be referenced as the contract that you sign or part of this lawsuit or the claim against you. It rarely ever is. So you have to analyze the contract and analyze the support of the breach of contract claim. The number 2 count will be the account stated count. The account stated counts, a lot of counts. In most states, a count for account stated, that's actually a collection lawsuit, because most collection lawsuits don't have the proper paperwork or the contract. So an account stated approach or counts, this is usually count 2, is how they file a pseudo breach of contract without the contract. However, while that must seem like it's a kind of a backdoor approach of getting you for breach of contract, to prove an account stated claim without the contract, they've got to jump through more hoops. And when they jump, you're right there to move the edge away so they don't make it all the way over. So a typical account stated claim is this, Shazam, and we're going to focus on 13 and 15. In Michigan and most states, the account stated statute requires it be brought with an affidavit. Why? Because you can't just say it. You got to explain it and support it. And an account stated statute usually references an affidavit, which again, as I always preach, the more documents they attach, the more you can poke holes in their claim, because they don't have the original stuff. They're going to kind of fudge their way through it. So you be the peanut butter to their fudge. I have no idea what that means. Anyway, an account stated statute generally requires the parties expressly agree upon the sum due, or the party receiving the account does not object within a reasonable time. So if you look at 13, Shazam, of the account stated statute, it says the plaintiff and defendant have consented to a sum as the credit balance due from one another on the account. That's sneaking in the account stated if you don't answer that properly or respond to it properly. And then if you look at number 15, Shazam, the defendant's payment and or failure to successfully question the state of the account within a reasonable amount of time constitutes admission of correctness. Ugh. But that's telling you we've got an account affidavit, and by the way, at least in Michigan and other states, if you don't answer an account stated claim that has an affidavit with a counter affidavit, you automatically lose very quickly too. So you'll go out there and find certain companies that are offering you answers on how to answer a lawsuit. If they don't advise you on the counter affidavit, they're wrong, and don't pay them a thing or get your money back. So in Michigan, if you don't file that counter affidavit, and in a lot of states, you're toast, all right? To use the food analogy again. The unjust enrichment count, Shazam, it's a throwaway. Most counts must live and die on their own, meaning if I just brought the breach of contract claim, there must be enough there within the four corners of the claim to be on its own. It'll have a supporting documents, but it wouldn't need an account stated or a unjust enrichment claim to support it. The unjust enrichment claim is BS. You can see that it says the plaintiff incorporates by reference paragraphs 1 through 18. That's not a count or a claim. It must stand on its own, or it shouldn't be brought, but it's brought. Why? Because attorneys and collectors are so insecure that they haven't brought the proper paperwork, and they haven't. They throw what did Phil Collins say? You throw enough S against the wall, some of it's going to stick. Well, it can all stick if you don't answer the lawsuit. So we've got to do our analysis using those first 3 videos I gave you, and now we have to answer the lawsuit. Attached to this video will be a template answer addressing all 3 counts for you to use in your state and your facts. So I'm going to give you some do's and don'ts. The do's: answer every pleading or paragraph. So if you miss a paragraph, so let's say there's one here, I think there's 1 through 22, you do 19 and you do 21, you better hope the 20 isn't significant, because it could be considered, if you will, an admission because you didn't answer it, and it's defaultable. It's something they could go in on. Hey, they didn't respond, they could default. I don't know if defaults are as fractionalized, but it has an admission type quality. Why get into that? So the reason I gave you that T and F, where you take the lawsuit, you go T is true and F, because that puts you on a guide. You've done all 22. Now you just take what you did, take the information from the summons, the gold you got from the summons, you look at the bill of sale stuff, and that goes into your answer. That's a do. And the other do is to carry over what you've learned in the analysis of using the 3 videos. The don'ts. Don'ts are always more than do's. Don't just deny or admit. Again, that's a company online that you're going, I need an answer. Deny, deny, admit, admit. No. Have a reason and a basis for your response to each paragraph and proof. And name them. Exhibit 1, Exhibit 2, Exhibit 3. You can look at my template and my many videos on counter-affidavits and how to answer a lawsuit of many different companies that I always have supporting documents, usually their stuff. The counter-affidavit, which is video 5, that's your stuff using their stuff. So don't file an answer without affirmative defenses and a counter-affidavit. An affirmative defense you file, and you'll see a template that I've attached, it must stand on its own also. A affirmative defense in most states is considered a pleading or a responsive pleading. So if you took one affirmative defense, and that affirmative defense is they filed against me in the wrong county. That should be enough there, and you can support it to file your own lawsuit. Each one you should look as mini lawsuits, and I tell you that because I don't want you to do boilerplate, meaning a lot of insecurity, again, especially with attorneys. They're fearful that they didn't cover every base, so let's say they need 5 affirmative defenses, they'll do 20, just so they think they've covered everything. Well, I've deposed collection attorneys and just wailed on them when it's discovered that they had no proof whatsoever for certain kind of affirmative defenses and outright falsehoods. So you're subjecting yourself, you're sticking your neck out if you say something that's not supported or true. Just let that be your guide and your conscience. So part 5 is coming up. That's the all-important counter-affidavit. But this is the answer and template affirmative defenses that will be attached to this video. This is part 4, and it's everything you get now, everything is going to go into your important counter-affidavit. We'll see you then. Thank you. All right, part 5. Now we have the most important video and part of your self-defense process. This is examining the collection lawsuit, part 5 of the counter-affidavit. So we're filing a counter-affidavit when answering any debt collection lawsuit. I'm not giving you advice on how to do your law or your life. Make sure that's part of your answer. Otherwise, it will not serve you to forget to do something that's, in some states, it's a requirement to have done. Especially in Michigan. In Michigan, if you haven't filed a counter-affidavit, they can file a motion for summary disposition against you if the case is based upon, as we talked about previously, the account stated statute. So always do it. And it's a good way to tell the court your side of things. And believe me, the collection lawsuit is a wasteland. There's nothing to it. So anything where you're informing and educating the court will appreciate that. So do it, please. It's a must, a do, an imperative, that you do this. A counter-affidavit is a legal document that says your side of the story. It will follow you through the entire process or the litigation process. You get a motion filed against you, Exhibit 1 is the counter-affidavit. You've got to file a case against them or a counterclaim, Exhibit 1 is the counter-affidavit. If you have enough in that counter-affidavit to refute their claims, you've got enough to do a counterclaim. You may want to not go that deep, but it may settle cases. But the counter-affidavit is your #1 skill and tool to win and settle these collection cases. Nobody else is doing it except me and you. Join the team. You can do this and swear under oath, under penalty of perjury, without a notary signing off on it, if you do it under 28 U.S.C. 1746. I'll have a template form attached to this video for you to see. I'll put 2 on there. It's a short video, but I'll put 2 on there just to show you, or use a template for your template. Here are 6 reasons why you should use a counter-affidavit. Let's put them up there. Shazam. It's the blueprint of the entire case. Your position, your defense, why they failed their burden of proof is in your counter-affidavit. It strengthens your defense. There's nothing worse when a client comes to me and they're looking down the barrel of a summary motion, and I look at their answer and it says admit, admit, deny, deny with no basis. The other side is salivating. They're just going to crush this poor guy. So you don't need me if you strengthen your defense with a counter-affidavit. It allows you to formally show the court your defense and why they did not meet their burden of proof. Challenge the plaintiff's evidence. What do? We use their documents against them. Heard me say that before? All that plonks right into your counter-affidavit. It prevents a default judgment. How's it do that, Parker, if I answered? Well, good question, Parker. If you answer a lawsuit in some states where you're going against an account-stated statute claim, the failure to do a affidavit countering what they had said in their affidavit is the basis of either finding you in default or, more commonly, winning against you a motion for summary disposition. There are specific statutes in some states that say if they file an affidavit, you've got to file a counter-affidavit. In Michigan, it says one step further. If you file a counter-affidavit and they don't answer, then they get in default problems and you can do a motion for summary against them. So that's a cool statute, and I'm sure there's many more like it throughout the land. It just heightens the importance of the counter-affidavit. Set the stage for discovery. You've let them know where they went wrong, and they rarely will amend their lawsuit to fix what you say. I've seen it once. I've seen it twice in 2 decades. I have never seen them fix their lawsuit. I've actually brought it to the court. I told them this 9 months ago. That piece of crap is still in front of you, Your Honor. So that'll set the stage of the questions you're going to ask. It's already written. The questions you're going to ask are really the issues you've brought up in your counter-affidavit. It travels with you, this piece of paper, this document. It's like the U.S. Constitution of you and your defense. You will just blast right through the process with this Exhibit 1 counter-affidavit. It sets up your counterclaim, and it even sets up your federal claim. If you want to go after the debt collector, you can show the court at Exhibit 1, here's what they did in the state action. They lost based upon my counter-affidavit. Here's their terrible lawsuit. Here's my counter-affidavit. Here's my answer. It follows you wherever road you want to take. Please drive the counter-affidavit car. Listen to me. So here are the steps to answer a collection lawsuit with the counter-affidavit. Draft the affidavit with all their documents. Make the affidavit an exhibit, usually Exhibit 1. It heightens the court's attention to it. File with the court. Always file your affidavit with the court. And when you're filing all the documents, which is really the affirmative defenses and the answer and the counter-affidavit, make sure you do a proof of service that says, I sent it to the court and I sent it to the other side. Always keep copies of everything for yourself, the things that were filed. Serve the other party with a demand. You've seen me talk many times. I'll go, hey, here's my answer. Here's where you screwed up. Here's my sworn client's affidavit. You want to settle this? Give me a walk away. And then if you have to, you bracket it down to a nice, feasible settlement for you. And then that's up to you how you want to do that. But you're not going anywhere without that counter affidavit. You don't get that choice. So here's my conclusion. 3 tips. Create the counter affidavit by relying on the analysis I just gave you in part 1 through 4. Whether you're dealing with a large debt or a small debt, always file the counter affidavit. It'll make every debt small, or it'll make it disappear. Use their own documents against them. Plunking alert, plunk everything you've got and learned from me that's in your case into that counter affidavit. Attached, I will have for you 2 counter affidavit templates so you can get a good start and handle on how you kill their case. Congrats, good luck.